So, we got some sentencing day material coming your way today. Life sentence and a death sentence. Ain't really much else I could say besides buckle your seatbelts.
Morning.
Morning, sir.
I just wanted to state that even though I was found guilty by a jury, I do respect their findings and their verdict. But at the same time, I do want the family to know I send them my deep apologies for what happened to their loved one. And I want to send them my condolences and let them know that I really didn't do this, and one day I hope to be able to prove that.
Did y'all believe that? No, these judges have a hard time, I'm sure. You know, trying to figure out if these people are telling the truth. I've seen a lot of these sentencing days, and I've seen some people that were facing, being sentenced for some very filthy, nasty, and disturbing charges. And when they get up on the stand and plead their innocence, I ain't gonna lie, some of them I actually believe. You know, it's like I think I got a good judge of character, but you just never know. And like this guy, he just said a calm and collective, somber plea, saying, I respect your opinion, apologizes to the family, but at the same time, he's still pleading his innocence and says, I wish or I hope that one day I can prove that I'm innocent of this crime. What do y'all think? Telling the truth? Very calm and collective, though. That's how it needs to be.
Mr. Newell, the 3-year firearm specification in count 1 aggravated murder and count 4 kidnapping do not merge for purposes of sentencing and must be served prior to and consecutive to the underlying offenses.
We know what that means, right? I'll give y'all a couple seconds to lace the comments and what consecutive means. She says, I'm not going to merge these charges. They are due to be ran consecutive. Scariest words I've ever heard. And now for anybody that doesn't know, that means all of his charges, they will not be combined. They will be separate. And he'll have to do time for each and every single one right after another.
You are convicted of count 1, the aggravated murder of Brianna Fluitt. You are hereby sentenced to serve 3 years on the firearm specification, to be served prior to and consecutive to the 3-year firearm specification.
Not bad. 3 years.
The total of 6 years on the firearm specifications will be served prior to and consecutive to a sentence of life with the possibility of parole after 30 years.
Well, why are we counting
With regard
then?
to the criminal gang specification in count 1, you are sentenced to an additional 3 years to be served consecutive to the underlying count. As to count 4 kidnapping, you are hereby sentenced to 10 years in prison to run consecutive to the sentence in count 1.
Ooh. That messed him up a little bit. Look, you see how he was locked in with the judge the whole time. He had hope. Judge did him dirty too. A little bit. Probably got his hopes up. He heard the 3 years, and then the 3 years, and then the 6 years, and he still has hope. He's like, shit, that ain't bad. That's what, 12 piece? And then life without parole. You stop counting after that. But right now, I think so far he's got life plus 20 and consecutive. So that means he's going to have to do a life sentence. It doesn't matter if he's doing consecutive or concurrent. He got a life sentence without possibility of parole. But he can't appeal. That's why the judge gives you all these other charges. Because if he appeals and wins the murder case, he still has like 40 years of consecutive charges to try to beat. So some people call that railroading in a sense.
Count 8, tampering with evidence with the 1-year firearm specification. You are sentenced to 1 year on the firearm specification and 12 months on the tampering to be served concurrent to the sentence already imposed. Finally, as to count 10, having weapons while under disability, you are sentenced to 12 months to be served concurrent to the sentence imposed for an aggregate sentence of life with the possibility of parole after 49 years.
So did he get sentenced to 2 lives? One without parole, another one with parole? Damn. You know, I don't think I've seen any sentencing day where the judge has said concurrent more than this one. This dude got smoked, man. Next up, I believe, is an individual from Florida. I could be wrong, but he's being sentenced to death for the murder of a deputy. During a routine traffic stop, I believe, he shot the individual 7 times.
You have been given the opportunity to be heard and show cause why judgment should not be imposed and offer matters of mitigation. This court has considered the aggravating and mitigating circumstances presented and has prepared a comprehensive sentencing order which is on file with the clerk.
You see how she uses words like aggravating and mitigating? Don't y'all find it very strange how in the courtroom where your life is at stake here, 90% of the words people don't even understand? I mean, in order to understand some of these words like mitigation and stuff like that, concurrent, consecutive, you either have to go through the court process of many failures and see it firsthand, or you have to be a lawyer. You know, a lot of normal individuals don't know nothing about what these words mean. And you know, that kind of gets me worked up a bit because it's like you can't even help yourself. You have to lean on someone else to help you. Someone that understands these lingos, these words. And I ain't gonna lie, it makes you feel very dumb in the courtroom that you don't understand any of the shit that's coming out of their mouths. Enlighten yourself, ladies and gentlemen. Go learn the law a bit. Don't hurt to read just a couple minutes a day about the law. Look up certain key words that go in the courtroom. Never know. You might need one day to know what they mean.
No legal cause has been shown to preclude the imposition of the judgment and sentence.
They say prelude and all this other quaaludes, all this other crap. Just say, look, there ain't been nothing, okay? Talk to me in layman terms. If she were to talk to me in layman terms, it would be, look, there ain't shit to say, okay? The guilty verdict, it is what it is, man. You lost. That's in layman terms, right? Nothing you can do about it, man.
This case involves a completely senseless murder of a law enforcement officer who was simply fulfilling her duties as a public servant by initiating a traffic stop. Deputy Pill acted professionally with the defendant during the traffic stop and provided him countless opportunities to exit the vehicle over the course of 3 minutes. Never did Deputy Pill take her firearm out of its holster, draw her firearm, or threaten the defendant. The bottom line is that the defendant murdered Deputy Pill in a selfish, foolish, and futile attempt to avoid returning to prison for violating his probation.
This is a completely understandable situation right here. I've gotten pulled over for something as simple as a DUI, but I know I'm going back to prison, right? I ain't gonna sit here and really break down what thoughts were going through my head on what I wanted to do to not go back to prison. But I also knew, even though I was drunk, that I don't want to go for life, right? And you know, you got to put yourself in everybody's shoes, even officers, man. And can you imagine how kind of on edge it could be pulling up to cars that look suspect as hell? You know, you don't know these people for nothing. They could be facing prison time because of you. Because you want to pull them over for out tail light, they could be going to prison because they're riding dirty, whatever the case. So you never know what's at stake with the next vehicle that you're going to pull over. A lot of officers lose their life simply just walking up to that window, asking for license and registration. That's the last words they say.
Planned well in advance of the shooting of Deputy Pill that he would do what it took to avoid incarceration, even if this entailed using a gun to shoot an officer. Despite ample time for reflection, to abandon his plan to avoid arrest, and even being urged by his then-girlfriend and trusted friend not to shoot Deputy Pill, the defendant did so regardless.
Hear that? The girlfriend even said, don't shoot her. You know, We don't know that for a fact, right? We don't know that. But she had to have said something to the detectives or whatever the case, because they're probably going to charge her ass too, right? Is that considered snitching? If she was like, I ain't shoot him, he did. I told him not to shoot. He didn't listen to me. Would you drop dime on him?
Not to just shoot Deputy Pill one time, but fired off 7 more shots. The defendant's brazen, premeditated, callous, and cowardly action of shooting Deputy Pill multiple times on a public street in a neighborhood of congested single-family homes mandates nothing less than a death sentence. Therefore, Brandon Lee Bradley, as to count 1, you are judged guilty of the crime of first-degree murder for the unlawful killing of Deputy Barbara Pill. For this crime, the court sentences you to be put to death in the manner prescribed by law.
State of Florida. So he's got life plus 15. Death plus 15 so far. And you see how calm and collective he is? Anyone and everyone, for the most part, knows you kill a cop, if they got the death penalty in that state, your chances are you're going to get it.